The purpose of this presentation is to give you the basics of law and liability with respect to shelter and rescue. I'm always pleasantly surprised how many people come to this presentation because I find it incredibly boring. But I think that people who do this for a living find it incredibly helpful. So I will continue to do it as long as as you guys keep attending. So I appreciate you being here very much. I'm going to talk about the following topics: the basics of liability, the basics of how courts approach legal cases. I'm going to give you case studies of individual cases. So I'm going to teach this as if you were in a law school class. And basically the way that's done is we give you the fact pattern and give you the court's holding and then explain how the court reached that holding. These are lessons and strategies. And then last, I'll give you some lessons and strategies at the end to try to incorporate the knowledge that we learned from the classes. This is the most important piece of information if you don't hear anything else, which is that I am not allowed to be your lawyer. By giving this presentation, I am not giving you direct legal advice. Rather, I'm giving you the information that you can take to your lawyer or to the people who are making decisions in your legal decisions for your organization to discuss with them, walk through it yourself, and make your own decisions. This is, in some ways, more designed for a lawyer to gather this information, use their independent legal judgment, but it's available for everybody. You will understand it. I will make it easy for everyone to understand, but I am not giving legal advice. I'm not allowed to do so. It would be against the rules of ethics for me to do so. What I can do is give you the information that's presented in the slides, and then you can make your own legal judgments with respect to how to implement that information. The law is different in every state. So if I give you a case that comes from a specific state, you can learn a lesson from that as best you wish, but that doesn't mean that it's exactly the same law in your state. Every state has its own liability law. And it can even vary by county or by appellate jurisdiction. So in Texas, for example, we have 14 appellate courts. If a decision has been reached by one of those appellate courts, but not the Texas Supreme Court, then it applies to the counties within that appellate jurisdiction. So that's a long version of saying you always want to talk to your own lawyer. You always want to work through these issues with your own lawyer, but what the purpose of this presentation is to help you issue spot. In other words, help you figure out what things are important, what things that we need to worry about, and then go devise your own legal strategy with your own legal counsel. The basics of suit and liability. The reason I have this slide in here is because I can't tell you how many times I've heard someone say, well, we can't do that, we're going to get sued. You can get sued for anything. You can get sued for breathing on somebody. You can get sued for anything. So when somebody tells you we can't do that, we're going to get sued, that's just silly. You couldn't leave your house in the morning if the possibility of getting sued prevented you from acting. What you should be concerned about instead is getting held liable. That's totally different. Getting held liable is, as is defined here by Black's Law Dictionary, the condition of being held responsible for a possible or actual loss, penalty, expense, or burden. So anybody can get sued. Liability is about what happens if you got sued and whether you could be held responsible for the action. Here are the basic causes of action. There are 3 basic causes of action that shelters and rescues should be concerned about. The first is negligence, the second is strict liability, and the third is premises liability. So basically, all negligence means is violating the duty to behave reasonably. That's the negligence standard. Did you fail to exercise ordinary care, the care that an ordinary person would have exercised under the circumstances? And most of the liability holdings across any jurisdiction are going to fall into that category. They're general negligence holdings. Second, there's strict liability. And what strict liability is, it's usually in the form of a statute. And what it does is it takes fault out of the equation. So they don't have to prove anymore that you failed to exercise the ordinary care that someone would exercise in the circumstances. Rather, they only have to prove, did the elements of the particular statute get met in that circumstance? And third, premises liability. Premises liability is a subset of negligence, and it has to do with the premises that you're on, and it has to do with causes of actions that are linked to the premises rather than an action. And so a premises liability, generally the most common case is a slip and fall, right? Someone comes into your shelter, you've recently cleaned the floors, and they slip and they fall, and then they break their arm and then sue you. That's a premises liability case. It's different from a strict liability, and it's a subset of general negligence. But you're going to see these three categories of cases when we talk about the individual case summaries. The elements of a cause of action, and we learned this on day one of law school. If anybody else in here is a lawyer, you learned it on day one of your torts class, which is that to have any cause of action, you have to have a legal duty to act in a certain way, a breach of that legal duty, meaning that someone failed to act in the way that the law required them to act, causation, which is that your failure to act in the way that the law required you to act caused somebody to be damaged or injured in some way, and then damages, which is the monetary value of the harm that you have caused someone. So let's go back to our slip and fall hypothetical. The duty to prevent a slip and fall, especially if you are in a corporate type place where you invite people in, such as a public open animal shelter, then generally you're going to have the duty to either cure a defect that could cause somebody harm or warn them of that defect. So this is why when you walk into Walmart, you see those yellow cones at the front that say slippery, right? They are warning you of the slippery condition. They don't actually have to cure the slippery condition. They can warn you. They can do one of two things. They can either cure the condition or the defect that will cause you harm, or they can warn you of it. So let's say they do neither of those two things and someone falls. Well, now we have a breach of the duty to have either warned you or cured you of the condition. Causation is if your failure to warn them is what caused the accident, and then damages are how did it hurt them? Was it the price of their medical bills? What was it? So that's how courts look at the basic elements of a cause of action, and the defenses to those, as you will see, are the exact opposite of the elements. So the element was duty, breach of duty, causation, and injury and damages. And the opposite of that, the defenses when you go into court, is there was no duty, there was no breach, there was no causation, there were no injuries. Those are all of your outs. When you're on the defense side, which is where I generally am in my lawsuits, these are all of your outs to get people out of liability. Is you say that there was no duty, that they didn't breach a duty, it didn't cause any harm, or that there weren't any damages anyway, even if it had caused a harm. And then in some places, including Texas, there are affirmative defenses. Well, there are affirmative defenses everywhere, but the affirmative defenses of sovereign immunity or governmental immunity is very protective in Texas, and it is in some other communities as well. This year, when I redid the research for this presentation, I actually found three different jurisdictions in which immunity played a role in defending the lawsuit against an animal shelter. So what I did, just so you know, is back in 2012 when I first gave this presentation, I read every single case in the country that I could find, every single published appellate case that I could find that had to do with an injury at an animal shelter or an animal shelter being sued. I read every single one. At the time, I don't know, there may have been 40. And then this past week, I updated the research, and I probably found about 20 more, maybe 10. So there aren't a whole lot of these cases out there, but I actually think that they are very instructive in how we should go about conducting ourselves in the animal shelter context. So this is the first thing that everybody worries about, right? I spoke to one of the shelter management guys in Amarillo on the way in. It was the first thing out of his mouth. You know, one of the things we're worried about is a liability after adoption. What if we adopt these dogs out and they bite somebody? So these were the highlights of the cases that I found. First one is Miles v. Rich. This is a Missouri case from 2011. The facts were that the Humane Society of Missouri adopted out a dog who then bit a third party, who then sued the owner. So the animal shelter itself wasn't sued in this case. The owner was, who had, yes. And then the owner turns around and sues the animal shelter saying, it ain't my fault, it's their fault. So dog is adopted out, dog bites third party sues owner, owner turns around and sues the animal shelter. And the court holds that there is no liability against the Humane Society in that context because it did not own, possess, harbor, or control the animal. In other words, that court held that once the animal belonged to someone else and it was outside of the control of the animal shelter, no liability attached. Which makes a little sense, right? You don't have control of it anymore. You can't do anything to warn anybody. You can't put a muzzle on it. You can't do anything once it's outside of your ownership and control. And there are tons and tons of those cases. I only highlighted one, but I probably found 5 or 6 or 8 of the cases where it was outside of the control. Once it was outside of the control or ownership of the animal shelter, it was held to be not liable. Galgano versus Town of Hempstead. Same type of facts. Town shelter adopts out dog who bites individual. Individual then turns around and sues the animal shelter. This was brought under a strict liability statute, and the court said no liability here because the plaintiff did not prove that the shelter knew or should have known of the dog's dangerous propensity. So if the shelter, here they found the shelter did not have any reason to believe, did not know that this dog was dangerous and therefore could not be held liable for the dog biting someone. And you're going to see that a lot in these cases. Tighe versus North Shore Animal League. This is a new one that I found this year. Dog adopted from the shelter bites the owner. So we have a slightly different fact pattern here. It actually bit the adopter after the adoption. And this is one that I think people worry about a little bit more because you have a direct relationship with the person that you adopted out to, whereas otherwise you would have a third-party relationship or fourth party or fifth party. But here is actually the dog bit the person who adopted out the dog. But here, again, the court says no liability because even if the shelter didn't warn of the dog's dangerous propensities, the adopter learned of the dog's dangerous propensity prior to the bite. So this is a causation case. This is different from the other ones. This is not a no-duty case. They're saying, yeah, you may have had a duty to warn of the dog's dangerous propensities when you're adopting it out to an individual, and we'll get to that later, but the general safe recommendations is to always disclose what you know about a dog. Always disclose. And so, but the court is saying, well, yeah, but even if you failed to disclose, if the person figured it out on their own and then the dog bit, well, they have decided to put themselves at risk. You did not have any additional information that they didn't come across on their own. So I thought that one was a really fascinating case. The court is saying the failure to warn of the dog's dangerous propensities wasn't enough if the owner found out about them on their own. Court goes on to say, so this was the rules as this court set them up. If the shelter informs the adopter of the dog's dangerous propensities, then there is no liability to the shelter for having adopted out the dog. So disclosed the information that the shelter knew about the dog. If the adopter learns of the dog's dangerous propensities prior to an injury, but after the adoption, still no liability, because the adopter had all of the information that the shelter could have given them about the animal. And it's really fascinating. The court says the rationale for such rule is self-evident. Informing a person who takes possession of an animal about the animal's vicious propensities allows that person to take precautionary measures to protect himself or herself and others from harm caused by that animal's vicious propensities. So if you have information about an animal, disclose it. That's what the court is telling all of us. Disclose the information. Now this one comes out a little differently. Lawrence versus North Country Animal Control in New York. This is another new case. Dog surrendered to shelter for aggression. The adopter, then it was adopted out again, and then it bit a second owner. The court held that the new adopter can bring a claim for fraudulent misrepresentation because the animal shelter did not disclose the truth, but instead downplayed the prior history that it knew. I have been warning in this class for the last 5 years. Cheryl knows because she's been to it every year, I think. I have been warning people every year since I've been giving this presentation of the possibility of someone getting held liable, of a shelter being held liable for saying good with kids, or good with cats, or safe with kids over 12, or whatever it is, whatever warranty that a shelter wants to give somebody. I have been warning that that liability is hanging out there, and somebody's going to get hit one day. Well, it finally happened. I predicted correctly. This shelter downplayed the information that it had about the animal, and the court said that the cause of action against the shelter could go forward because you misrepresented the information that you had about the animal. Second important point on this case is there was an adoption waiver, and this is highly legally technical, but I'll try to explain it in a way hopefully that makes sense. The adopter did sign a waiver, and I get to that later on the back end of this presentation about the importance of waivers. But it held that the waiver did not bar liability because the waiver did not expressly waive liability for the shelter's negligence. So this is something I actually only learned myself in the last 5 or 8 years as a practicing lawyer. And that is that a waiver only, in some jurisdictions, a waiver will only be held to work if it expressly identifies the waived party. The party whose negligence is waived. So if I am in an animal shelter and I say to the adopter, you waive liability for any and all acts with respect to the animal, I would have thought that would have been enough as a general person, right? But it turns out you actually have to say you waive any and all liability for the actions including the negligence of the animal shelter. Then you have met what is called the express negligence rule. Here, the court said that they failed to meet the express negligence rule, the rule that requires you to expressly identify the animal shelter or rescue, the party for whom you are waiving liability. Does that make sense? Yes? Good. I know it was a little more technical than the rest of the stuff. All right, so the next thing you hear is, well, we can't have volunteers, right? We can't have volunteers because we're going to get sued or we're going to be held liable. And so we looked into those too. I looked into those too. Here's the most recent case I could find, Blake versus County of Wyoming. Volunteer was bit by a dog while volunteering at the animal shelter, and the court held no liability because the shelter did not have actual or constructive knowledge of the dog's vicious propensity and failed to inform the volunteer. So I told you a minute ago, we're going to see that over and over again. If the animal shelter did not have knowledge of a particular dog's propensities, then in these cases, they're not held liable for failing to warn the person of the dog's propensities. Morris versus Best Friends Animal Society. A few of you have probably heard of this defendant. This was also a very, very recent case, 2018 case. A volunteer was attacked by a dog while volunteering at the Best Friends Animal Shelter in LA. The court held no liability because the volunteer had signed a waiver of liability that included an express negligence provision. So I'll stop here for a moment. I actually got that waiver from Best Friends. And so if anybody wants the waiver then that Best Friends wrote, you can email me. My email address is rdclinton@gmail.com, rdclinton@gmail.com. If you want Best Friends waiver, I'm not telling you to use it. I'm not telling you not to use it. I'm telling you to bring it to your lawyer. But if you want to see their waiver, I got a copy of it after I found this case, and I am perfectly happy to send it to you. But I just thought that was very fascinating that I'd found the other case that said the waiver didn't work because you had not met the express negligence rule, meaning you have to identify the person whose negligence is liability is being waived for. In Best Friends, it says in their waiver, it specifically says You're waiving for any and all liability with respect to your volunteerism, expressly including any negligence by Best Friends Animal Society. So they met the express negligence rule. So you learned something this year, Cheryl. This is my new contribution. Brown versus Northwoods Animal Shelter. The facts were the volunteer worker slips and falls. We're all worried about slip and falls, or we should be anyway. Volunteer worker slips and falls at the animal shelter, then sues the shelter for personal injuries. This is a premises liability case because it has to do with your duty to either cure or warn of defects in the premises. And the court held no liability because the volunteer had signed a waiver of liability. So waivers very frequently work. And they especially work if you meet that express negligence rule that I talked about. Fire Insurance Exchange versus Cincinnati Insurance. This is where basically the litigation was between the insurance companies who had insured the parties at issue. So that's why the name is a little weird. But basically the facts were that dog bites a 12-year-old who was volunteering at the Rock County Humane Society. Here, the court held that the parent's signature on the liability waiver did not defeat the claim because shelter may be deemed to have violated child labor laws and because I am told, I'm not a labor lawyer, that in some jurisdictions, parents cannot waive liability on behalf of their children. So this is a question that comes up a lot, that people ask me a lot, and my answer is always, I am not a labor lawyer. I asked a really good labor lawyer in Austin this question, and his recommendation was not to allow kids to volunteer. Everybody's got to make their own decision. One of the things that you can do, obviously, is limit the possibility of a child getting injured, and you can do that in any number of ways. So you don't, if you chose to accept some risk, you could. But you ought to know that there is at least precedent out there suggesting that having a parent sign a waiver form is not going to get you out of liability should a child get injured. What about adoption sites? There are a bunch of these cases too, because again, you hear it. Well, we can't have off-site adoptions, too much liability. I mean, all of these things we hear, we can't do this because there's too much liability. And so then what I did was I looked into it, found the cases, and then over and over and over again, you see the courts concluding that there is little or no liability in these interactions, with the exceptions that I've noted. So here's the first offsite that I found. This is a recent offsite adoption case. Abrams versus City of Mount Vernon. This is another New York case. Dog bites prospective adopter visiting the animal shelter. And I thought this was interesting because there were a couple of these for the first time in the case law, where somebody is coming to the shelter to interact with the dog for the purpose of adoption and a dog bites the prospective adopter. Here they said no liability because the shelter was not aware that the dog had vicious propensities. Again, we see that over and over again. If the shelter is not aware, then they're not holding. These cases do not hold the shelter liable. Collapse versus Animal Haven, also in New York. This is a Petco site. So a lot of people, I'm assuming many of you have offsite adoptions that are in Petcos or PetSmarts or other locations. This is the one that I found of those. Dog available for adoption outside Petco bites a Petco customer walking by, having nothing to do with the adoption site. Customer sues the animal shelter, and the court held no liability because the shelter did not know or have reason to know of the dog's dangerous propensities. I hope you're getting the point there. And obviously the opposite of that is if you know of the dog's dangerous propensities, then this is not going to be an out for you in litigation. Collins versus County of Vermilion. Facts were that a dog bit a man who stuck his hand into the dog's cage when he was looking for dogs at an animal shelter. And the court says, this was interesting. This is an Illinois case, so this is a strict liability statute. I have never seen a statute as strict as this one. That statute, which is on the bottom, says, if a dog injures any person who is peaceably conducting himself in any place where he may lawfully be, the owner of such dog is liable for civil damages. That's what the statute says in Illinois. There's no out for no knowledge of dangerous propensity. right? There's no out. So the court, interestingly, what happened here is the trial court held on a summary judgment that the shelter was liable, and the Court of Appeals reversed, saying we don't know if the adopter was allowed into the cage that he stuck his hand in. Because the out here is that he has to be peaceably conducting himself in any place where he may lawfully be. And so the court said, well, we don't know if he was lawfully allowed to be in the adoption kennel, so we're going to reverse the summary judgment on behalf of the plaintiff on that ground. But however, this should be a warning, I think, for anybody in Illinois that this is something that you probably need to be aware of and make an adjustment for. But that's the only case that I could find that has the ability to hold somebody liable who, regardless of whether they knew of the dangerous propensities, regardless of if they, I guess a waiver might have gotten past this. That would be what you'd want to do in Illinois. But there are very few cases like this. This one and the fraudulent misrepresentation were the two that I found where people were allowed to go ahead and sue an animal shelter. So don't make fraudulent misrepresentations, and be careful if you're in Illinois, would be the two lessons from those two cases. All right, what about pet custody disputes? I was shocked at how many there are. Apparently people really like to sue over pet custody. So here's a Vermont case, Lamar versus North Country Animal League, which is that the dog was impounded as a stray for the 9-day hold period, then transferred out to a nonprofit after the expiration of the entire hold period, then adopted out. Prior owner finds out, is denied the adoption from the nonprofit that has it, and then sues the nonprofit. And the court holds no liability for public policy reasons. The nonprofit shelter gained complete ownership of the dog after the expiration of the hold period, which I think is the right decision, but it turns out that's not what we see necessarily in other jurisdictions. Here's a West Virginia case, Haynes versus Hampshire County. Dog impounded as a stray, held for the entire straight hold period, then adopted out. Prior owner sues the county, held no liability, again for public policy reasons, but noted that had the county still owned the dog, it might have ordered it to be returned. So interesting facts there. That's called dictum, when a court tells you something about what the law might be, but isn't under the facts of the case at issue. So the court is kind of flagging, well, we may have thought differently about this if you still own the animal, but we're going to hold that the animal shelter is not liable because at the expiration of the hold period, the animal shelter became the owner of the animal and had every right to transfer it. That should be the law. It is not the law in Texas. In 2016, the Texas Supreme Court had a case of Lyra versus Greater Houston German Shepherd Rescue. Dog was impounded, held for the entirety of the hold period, then transferred to a rescue group. Prior owner finds out, then sues rescue group. Same fact pattern we see in the other two. The Texas Supreme Court holds that the dog still belongs to the prior owner. And its reasoning for that decision was that the hold period ordinance at issue in Houston did not expressly transfer ownership at the expiration of the hold period. So basically they were holding that in order for the government to take your property, the government has to inform you of your rights. And here they're saying that the government hold period ordinance failed to inform the property owner of his or her rights. Now, the way around this is pretty obvious to everybody who's looked at it, which is change your hold period ordinance and make your hold period ordinance say, as Austin's now does because I wrote it. It says, at the expiration of the hold period, ownership transfers to the animal shelter, period. That's all it had to say, and the outcome of this case would have been different. So while it is a terrible case, in my opinion, and wrongfully decided, anybody who's paying attention can adjust their hold period ordinance to make it expressly transfer ownership at the expiration of the hold period, and then you don't have the problem of the animal shelter not owning the animal. And I'll have to answer questions afterwards.
Can you repeat that phrase again, at expiration of hold period?
If you're in Texas, this is only a Texas case, I have not seen this anywhere else. that you will want your hold period to say that, your hold period ordinance to say that at the expiration of the hold period, ownership transfers to the animal shelter. Title to the animal transfers to the animal shelter. And if you'll email me, I can send you a copy of Austin's so that you can take a look at that one. I think, Cheryl, didn't you adjust yours as well? Has anybody else adjusted their hold period ordinance based on LIRA? No? Who else is here is in Texas? All righty. Well, I'm glad you came, because if you hadn't seen anything else, I do think that's a very, very important thing for municipalities to do, to adjust their hold period ordinance so that ownership transfers at the expiration of the hold period. The court didn't go there, didn't get any further than that, but think about what it means if ownership has not transferred at the end of the hold period. It means that spay-neuter that you did may have been illegal. It means that if you euthanize the animal, you may be responsible for it. Okay? So as fast as you can would be my personal advice. I'm going to try to answer questions afterwards, I'm sorry. That would be my advice. Fager versus Warwick Animal Shelter. This is New York. A prized show cat was allegedly stolen from a woman's house, surrendered to the animal shelter, and then adopted out to a new owner. The prior owner finds out, sues the shelter, and here again we have weird facts, which is the court holds that the suit can go forward if and only if the plaintiff proves that the shelter knew the cat was hers and adopted it out anyway. So if you have this factual circumstance in which you know that an animal belongs to someone, then you need to exercise far more care in looking for that owner and giving that owner the opportunity to get the animal back. This was the only case I found in which LIRA was actually against the rescue group, not City of Houston. I'm not sure what would have happened if they sued the City of Houston. But this is the only one where I saw that the custody dispute was brought against the animal shelter, and the court did find that suit could go forward, but only if the shelter knew. And so basically what I think that the court was, it was a small community. I think the court was kind of concerned that the shelter employees knew that this show cat was stolen, and they kind of pushed it under the rug and got it adopted out instead of returning to its home. That's kind of when you read between the lines, what you assumed happened. All right, a couple of miscellaneous cases. This one has to do with foster to adopt situations. Who does foster to adopt? Yep. The dog foster in a foster to adopt situation refused to return the dog to allow it to be spayed. She had done some research and determined that it was bad for the animal and that she could no longer be the type of performance dog that she wanted her to be. The animal shelter, and she had been transferred to a rescue group. The animal shelter, by the way, threatened to terminate the rescue group's ability to rescue because this foster of theirs had not spayed or neutered the dog. There was a written foster agreement that made clear that the rescue group owned the animal, but it did not technically require a return for spay-neuter, so that's what the fight was about. And the court held that the foster was ordered to return the dog to the rescue or have her spayed, and said that and my note here is that the contract, at least what the court seems to imply, is that the contract should have been stronger on the ability to require the foster to return the animal on demand. So again, this is basic. The court went to the contract to decide who owned it and who was required to return it. But we all have these foster to adopt situations where there's kind of like, well, we're not really sure who owns the animal while it's in a foster to adopt situation. And the court's saying, look, you need to define it clearly in your contract, who owns the animal and what are the responsibilities. And so if you want the ability to take that animal back at any given time, you need to make sure that it's in your foster contract. I mentioned governmental immunity as an affirmative defense at the beginning of this, and basically governmental immunity stands for the position that it doesn't matter. All of those facts, all of that stuff we talked about, none of it matters because the only thing that matters is this entity can't be sued for that action anyway. And so City of Elgin versus Reagan is the Texas case on this list. This was a mauling of an adopted dog by the owner's child, I believe on the afternoon of the adoption. It was not in the case, but I read in news reports that it was apparently a former police dog, and the owners were not informed that this dog was a police dog. It's a big German Shepherd. And even in those horrible circumstances of a shelter purportedly knowing that the animal was vicious and not telling the adopter that the animal was vicious, and then the adopter's child being mauled by the animal, the court held no liability because of governmental immunity. Now, note for anybody in Texas, this is a decision that's been reached by the Austin Court of Appeals, which has a number of counties, but has not been reached by the Texas Supreme Court. So that means that this is persuasive authority, should it come to a jurisdiction other than the Austin Court of Appeals, but it is not binding authority on a court because it hasn't yet been reached by the Texas Supreme Court. But you see similar cases in Alabama and in Ohio, where there was a loose dog, somebody sued the animal control officer or sued the city. Those weren't adoption cases, those were loose dog cases, where someone had accused the animal control of failing to protect them from a loose animal, and then those instances the court held that it was barred by immunity. Okay, now let's talk about strategies to reduce your risk. Now that we know what to be worried about. The first half hour is to get you in a panic, and the rest of it is to hopefully dial down your blood pressure a little bit. Strategies for reducing risk. Basically, they're the 3 C's. You conduct yourself in a way that reduces your risk. Contract, meaning that you require your contracts and your agreements reduce your risk. And then, of course, cover yourself, which is insurance, meaning that to the extent that something happens, you need to have insurance to be your last backstop to reduce your own personal liability. Just so you know, the first thing that corporations generally do, or that organizations generally do to reduce liability, is to incorporate. When you incorporate, it is a legal myth that the liability then is owned by the corporation and not the individuals running it. So that's why we incorporate. I would strongly recommend anybody to incorporate if they're running a rescue group or a private animal shelter. Once you incorporate, you take risk off of yourself. There are exceptions, but for the most part, you're going to take the risk off of yourself, and the risk of liability goes to the corporation. It also is required for you to get a 501c3 anyway, if you were interested in doing that. On adoptions, you want to observe, document, and disclose. Basically, you want to tell the truth about the animal. Always tell the truth. Where animal shelters are getting in trouble is when they don't disclose the information that they have about the animal shelter, or they make promises about the animal that they can't back up, like good with kids, or good with cats, or good with other dogs, or whatever it is. When you are making a promise or a representation regarding the animal, you are setting yourself up for potential liability. So I say, stick to the facts, tell the truth, and disclose what you know about the animal. Warranties, promises, and predictions should be off limits. And you should tell your staff this too, by the way. Staff, volunteers, nobody should be in the business of telling prospective adopters how that animal is going to behave in the future. That is what potentially could put you on the hook for a fraudulent misrepresentation claim. Stick to the facts. So a fact would be that the animal has lived in a foster home and there have been no instances of concerns. That would be a fact. But not a fact is good with kids or good with other dogs and cats, because that's not a fact. That's your opinion, and you're making a representation about how that animal will behave in the future. First of all, you're not an expert, and you don't have the background. In fact, nobody does. Animals are inherently risky. Nobody has the background to be able to predict how a particular animal is going to behave in the future. No one should be making those representations. With respect to your premises, I made this when we talked about the claim early on. Your duty is to either warn or make safe of the conditions. If you are inviting people into your premises, so if you have a shelter that's open that people can come to, you also have a duty to go and take a look at your premises to affirmatively go find potential defects. If it's just your house, that you're not inviting people to, right? You're not inviting the public to come buy stuff at your house or adoptions at your house. You're just talking about your own personal house. You don't have a duty to go seek out and fix defects in your own personal house. But if you're at a place or a place of business where the public is invited, you also have a duty to seek out problems. So we're talking about wet floors, tripping hazards. I think you should be concerned a little about gates that could open, that have broken handles. Things like that are the things that you need to think about with respect to finding defects and fixing them or warning. You want to have policies and procedures that reduce your risk as well. So written policy protocols for your employees, your volunteers, even your board members if you have them. Safety training for all employees and volunteers, employment law training like sexual harassment. These are all things that you could be potentially at risk for in liability-wise, and you should do everything you can to reduce those risks. Waivers and agreements are one of the best ways that you can reduce your risk of harm after an adoption. So an adoption agreement should, again, disclose all behavioral and medical information, any observations that you have about the animal. Include, by the way, if this has been a previously owned animal, if there are surrender notes. You want to make people aware of the surrender notes. If the animal's been in a foster home and the foster has taken notes, has information, include that. Basically, you just want to tell the truth. The whole truth and nothing but the truth. Give the adopter the same information that you have, and then the adopter will be unlikely to hold you liable for failing to give you information. And remember what I talked about earlier, the express negligence rule. You want to expressly state that the adopter is waiving liability for the actions of any party, including the rescue or animal shelter. I also think that every adoption agreement should warn that animals are, of course, inherently unpredictable and may subject the adopter to any number of health and safety risks. That's simply true. Adoption agreements may also disclaim oral representations and promises, by the way. If you're concerned that you need to tell your staff. I would recommend telling your staff not to make promises, but you could even have a disclaimer in your adoption contract that is yet another defense behind that says, look, no representations of any kind are valid here. Make clear. And then also make clear that ownership of an animal transfers upon adoption. There was a case in New York that I took out of the slideshow, but in that case, the rescue group had a line in the contract that said that we have the ability to come take the animal back at any time, should we so choose. And so the issue in that case was whether or not the rescue group had retained ownership of the animal by claiming that. And if they had, then they could be held liable under New York's strict liability law. So most lawyers advise you not to include language in your adoption agreement that gives you rights as the animal shelter even long after the animal has been adopted, because it could potentially put you back on the hook as owner of the animal. You can consider an arbitration or mediation requirement in almost every corporate contract today. Everything goes to arbitration. How many of you have cell phones? I'm guessing everybody. And so when you got your cell phone, you clicked okay, 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 okay about 8 times at the beginning of that, and none of you read it, right? One of the things that you agreed to was that you couldn't sue any of the people related to that cell phone. You agreed to that it would have to go through binding arbitration, which basically means you go before a person who serves as an unofficial judge who just makes the decision, and you can't appeal it. You're done. There is risk in arbitration clauses because you can't appeal it. And so if the arbitrator makes an horrible decision and holds the shelter liable, even though the shelter should never have been liable, that too is unappealable. So there are great risks in arbitration clauses, but I wanted you to be aware of them. Foster agreement, basically the same thing as the adoption agreement. Disclose everything you need that you know about the animal. You do not want a dog that you know has a propensity, has some propensity for dangerousness to go into a foster home without first disclosing that information to the foster. It's not fair to the person, and it potentially subjects you to liability. Same thing, state that the animal is unpredictable, that animals are inherently unpredictable, and make sure in your foster agreement that it is clear that the animal shelter retains all ownership of the animal, and the animal must be returned on the demand of the animal shelter. That's what I put at the top about make sure that people know who it belongs to. You may, should you choose, make clear who's responsible for medical costs during the fostering period, who's responsible for food costs during the fostering period. I personally think that people should generally separate to the extent that they can foster animals. So if they're fostering 4 or 5 kittens, put them in a bathroom and keep them separate from their other animals. But these are the types of things that you can put into your fostering agreement, should you so choose. Volunteer agreement, again, we're talking about the same things over and over and over again. Make sure you require them to waive liability. Make sure that they know who owns the animal. Make sure that they understand that animals are inherently unpredictable. The safest practice, I have been told, again, I'm not a labor and employment lawyer, is adults only, but that's your choice and how much you want to expose, how much risk that you want to take on, and how much risk you're comfortable with. And by the way, all of this is a business decision. People think that legal decisions are decisions that happen in the air in the absence of context. They don't. All legal decisions are business decisions. So, for example, if it's really, really important to you as an organization to have kids interacting with kittens, you can do that. You just have to be aware that in doing so, you're accepting some amount of risk, right? But it's less than if you allowed kids to interact with very, very large dogs, right? So you may have different rules for different animals. You may have different rules for different age groups. All of these are your business decisions that you get to make the decision of how much risk is here. We read a whole bunch of cases that suggest there's not a whole lot of risk. That's what those cases suggest. But you get to decide how much risk you want to take on. And last, insurance. So workers' comp insurance is generally what you would need with respect to your employees. General insurance to cover operations, volunteers, premises, make sure that it would cover offsite adoptions. You even have to get insurance to have events like this one, believe it or not, because I previously put on some of these events and I had to buy an insurance policy for the date of the event, I guess, to make sure if somebody slipped and fell, if somebody got harmed in some way. So insurance policies, you can find a broker and they will find what you need. Automobile insurance, obviously you want to make sure if people are transporting animals for you, there is some liability with respect to the automobile being transferred on, being used for your rescue or shelter. You want to obviously make sure that anybody who is operating an automobile for you is covered by their own insurance and has a driver's license and doesn't have, and you'll probably want to do a background check to make sure that they don't have a bad driving record. Events, you want to get supplemental insurance for. And then lastly, two more notes with respect to insurance. One is that when you have insurance, if you have an incident, what happens when you get in a car wreck with your car insurance? It goes up, right? Well, the same thing happens with shelter insurance. If you have an incident, your insurance is going to go up. So I know of a nonprofit that did have insurance. An animal went to foster that they knew had a dangerous propensity, and the animal was in the backyard. The neighbor stuck his hand over to pet the dog, and the dog severely bit the neighbor. Okay? Now, what could we have done in that situation? Well, A, we want to make sure we've got waivers for the foster. I actually think we need to have, I think it's important to also have clauses in that foster agreement that say that the foster will be agreed to be primarily liable for any harm done by the animal while it's in the foster's care. And then, so you can do it by contract. You have the insurance, but let's think through this. If a dog with a dangerous propensity that you have knowledge of is going to a foster home, why not make sure they have a 6-foot fence? You know, why not make sure that they're on a leash at all time, or they have a muzzle if they're, I mean, we're talking about a small fence, you know, that anybody could have put their hand on or put their hand over. I mean, I think that we have to just be rational. Part of this is just common sense, right? If you have a particular dog that you know is dangerous and it's going into a foster home or whatever, act accordingly and make sure that the public is safe from that animal, however it needs to be safe. Last note on insurance is that Frost Insurance is one of the sponsors of this event, and Frost Insurance is one of the only insurance companies that provides insurance for shelters or rescues. So they are here, they have a booth, and if you're interested in talking to them about insurance, I would encourage you to do so. So that is the end of my presentation. Keep calm and rescue.